We continue to read this divorce case in the Supreme Court. Mrs. Moureen Sinclair, who filed for divorce, versus Mr. Wesfore Sinclair, her husband. Now we continue. We had looked at the evidence for the claimant, Mrs. Sinclair, already. Let us now look at the evidence of the defendant, Mr. Sinclair. The defendant contends that despite the fact that the Cherry Gardens property is registered solely in the name of Mrs. Sinclair, he has been solely responsible for repaying all of the mortgages in relation to the loans for the construction of the house and the land. So he is entitled to an interest in that property. So because she was asking for 100% interest in the property because her name is the one on the title. But Mr. Sinclair says that he had paid money towards it. We continue. In his evidence in chief, he states that his wife agreed that the title to that property would be used as collateral, and he agreed that all loan financing obtained would be repaid by him. He refuted her claim that she had commenced construction prior to the receipt of the mortgage. So she claimed that she started constructing the house before Mr. Sinclair borrowed the money. But Mr. Sinclair says, no, that's not so. All right. He admits that at a point in time, Mrs. Sinclair had offered to place his name on the title as an owner, but he declined that offer. Mr. Sinclair refutes Mrs. Sinclair's claim that the sums borrowed against the title were done without her knowledge and consent. He states that she was aware of all the sums borrowed, in that the mortgages could not have been registered without her consent. He further states that Mrs. Sinclair signed the mortgage loan documents in the bank. Whoa. So Mrs. Sinclair is saying that she did not know anything about these mortgages. But then the title is in her name and she signed them. So how could she not know? Whoa. He explains the reason for an additional loan of $13 million from the Bank of Nova Scotia. He states that the sum was required as a retaining wall that was built on the property had collapsed because of dumped up land and had to be rebuilt urgently to secure and preserve the house. He admits that he asked Mrs. Sinclair to agree to a further loan financing that would be secured by the Cherry Gardens property. The reason for that loan, he explains, was to secure further funds to complete the construction of the house. Mr. Sinclair denies that any further borrowing was done without Mrs. Sinclair's knowledge or consent. He states that he gave Mrs. Sinclair various sums for expenditure throughout the construction and furnishing of the Cherry Gardens house, so she would have evidence of those expenditures. He says that the construction of the house is not complete and that the unfinished portion includes the master bedroom, the basement, and the pool. He also states that he was desirous of consolidating all his loan obligations so that as to attract a reduced interest rate and thereby reducing his mortgage payments, as he was experiencing financial difficulties in meeting his loan obligations. He, however, states that Mrs. Sinclair did not agree to that. On cross-examination, Mr. Sinclair says that the Pines Imaging Center Limited commenced business in 2001. No money was borrowed to benefit the establishment of Pines Imaging Center Limited using Cherry Gardens as a security, as the property at Cherry Gardens was bought in 2004. He also says that he is not sure if Mrs. Sinclair gave personal guarantees over loans to benefit Pines Imaging Center Limited. He asserts that whatever she does as a shareholder in the company would have been done by multiple shareholders, as other shareholders gave unlimited guarantees. He states that the Pine Imaging Center Limited has borrowed multiple loans. He also agrees that in 2012 there was a second legal mortgage over Pines Imaging Center Limited, and that the document relating to the mortgage indicates an unlimited guarantee by Moureen Sinclair. He explained that in relation to the mortgage, there is a group of shareholders in Pines Imaging Center Limited. The company was seeking to acquire an MRI machine with a loan from Scotiabank, and being shareholders, they were using property from the company, including the machine and the Cherry Gardens property, which by then had a house on it, as security. He contends that the Cherry Gardens property by then would have been owned by himself and his wife, because by then the house would have been on the land. Mr. Sinclair maintains that his wife is allowing the property to be used as security. In allowing the property to be used as security, was not doing this for him, because as a shareholder, she would have been doing this for the benefit, for her benefit as well as the benefit of other shareholders. He admits that there were times when he defaulted on the mortgage for the Cherry Gardens home, and that they are not currently up to date. He, however, asserts that he can afford to service the mortgage. He says that in and around 2016, he approached the Bank of Nova Scotia to restructure his loan, and that they agreed to consolidate his loan and reduce his payments by half, for him to pay approximately $800,000 per month. They also agreed to give, so you hear those mortgages, $800,000 per month. They also agreed to give himself and his wife a further loan of $10 million to complete the house, but his wife refused to sign the documents. He says that this is the reason why the house has not been completed. He says that during that period of time, he struggled to pay the mortgage, but he always pays even if it is paid late. He asserts that it will be paid. We will look at further parts of this document in our next video. The next section is titled The Law.